Hello and welcome to another episode of ME-Arcone Queing, brought to you by the Institute for Alternative Dispute Resolution, New Delhi. I'm your host, Shreyansh Srivastava, first-year law student at Institute of Law, Nirma University, and an intern at the Institute for Alternative Dispute Resolution. We are continuing our 15th season, and this journey is into the real-world practice of dispute resolution beyond the textbooks, beyond the bare acts, and into the actual room where the conflicts are resolved. Before we begin, if you're enjoying this season, please take a moment to leave a comment or share this with a fellow law student or practitioner. It helps us to grow this community. Now, let's dive in the theme. So, our broader theme this season is Voices of Resolution, promoting harmony through communication and understanding. But for today, we are narrowing this lens to explore something I think is particularly relevant for young professionals. We are calling this a specific conversation, building a career in ADR from law school to leadership, the Singh story. Because here's the thing, one of the biggest questions we hear from law students is, how do I actually build a career in arbitration and mediation? Where do I start? Sir's journey offered a remarkable answer, from graduating from Jindal Global Law School to becoming a CEO of a major arbitration center, from participating in training programs to leading institutional initiatives. His path is both inspiring and instructive. To help us all unpack this, we have exactly the right person with us today. Our guest today is Mr. Singh, a dispute resolution professional whose career trajectory is nothing short of remarkable. Sirs is a legal professional working at the intersection of law and public policy. He previously served as a global operations director at ODR International, where he planned and executed training programs in civil and commercial disputes resolution across 45 plus countries and oversaw end-to-end global operations. He also contributed directly to the curriculum delivery as a junior trainer in the civil and commercial mediation program, working closely with the participants across jurisdictions. He is an accredited mediator with SIMI, IMI, and CMC, a certified mediation advocate under the Standards and Competencies in Mediation Advocacy UK, and a certified arbitrator, negotiator, and digital dispute resolution specialist. Credentialed across both traditional and digital dispute resolution, he has received training from leading institutions including the European Institute of Conflict Resolution, ADR, ODR International, IIAM, School of Negotiation, DIAFC, Dubai, and APC-AM. His expertise spans alternative dispute resolution, energy law, environmental law, climate change, and space law. Academically, he holds an LLM in ADR from OP Jindal Global University and a BA LB honors specialization in energy laws from UPES Dehradun, and is currently pursuing a PhD in cross-border mediation. He is also an alumni of the Global Policy, Diplomacy and Sustainability Fellowship, where he engaged with international political economy, diplomacy, climate change, and sustainability. Alongside his professional work, he conducts pro bono legal awareness sessions in rural communities. Sir, it is an absolute honor to have you with us today.
Thank you so much for this generous introduction, Shreyansh. It's a pleasure to be here.
So, sir, if you're fine with, so we will begin with our conversation. And so the very first question to you will be, so your career trajectory is genuinely inspiring, from graduating at Jindal Global Law School to becoming the CEO of and executive director of SACADR, all while being an active arbitrator and mediator. It is remarkable. What was your vision when you started out? Did you always know what you wanted to be, or what you wanted to build a career in ADR, or there was a turning point? And what would you say what were the key decisions that shaped this journey? So
Sure. So to quickly begin with, ADR never ideally was my first choice. So if you look at my background, as you've rightly pointed out, I did my bachelor's specializing in energy laws.
Yes, sir.
So a large part of my interest back during my undergraduate days was in energy and environmental laws, which is why I was really passionate about working in that domain and climate change particularly. It was, I would call, a destiny rather than my own particular choice to begin with. So I applied for a program in environmental law at Jindal, but because of the time restrictions, because I applied a little late, there were no seats left in that program. And that is when I had a few options left in front of me, out of which ADR appeared as the most lucrative choice. So that is how my journey with dispute resolution began. Over the course of next 1 year, I got to know a lot about arbitration and mediation. So in undergrad, we just had one subject on ADR. But during my master's, I got an opportunity to read about these subjects individually in more depth. And that is something which really fascinated me. I started looking at disputes from a very different lens altogether. And I think that's where my actual interest and the vision started shaping in. So by the time I was out of my law school, so by the time I was about to complete my master's from Jindal, I was really passionate about working in the dispute resolution sector, and I started my journey with trainings. So the first training I remember that I did was in mediation advocacy. Then I did a training in arbitration. And while these trainings, I had the opportunity to interact with a lot of professionals who are already working in this domain. And that gave me a brief idea about how should I actually start. So, I mean, I was already, because of the trainings, a part of a different kinds of network of these arbitrators and mediators across the country. And that gave me a sense that these activities were by and far and large restricted to the metros. So, I mean, we used to do a lot of activities in places like Delhi and Bombay and Bangalore for that matter. But nothing happened in tier two cities. And given that I originally belong from Varanasi in Uttar Pradesh, so I always plan on going back to my hometown and setting up a law firm there. And that is where the entire idea of setting up SACADR, which I love to call it as, but it's the South Asian Center for Excellence in ADR. That's where the idea came in from, because I wanted to use this institution not just to provide arbitration and mediation services, but the vision was beyond that. The vision was to create awareness and trust amongst the people. Because when I went to the courts for the first time, so I started my journey practicing in the law courts. And when you talk about mediation in law courts, the kind of response that you will hear from the parties and the lawyers is not something you will enjoy a lot. There is a big lack of trust, and they think it is nothing but just a settlement of some sort. And when you hear the word settlement, you think about compromise, which is not something any party would want who is thinking about going to a litigation, right? So the idea was to build that awareness, to bring that trust in. And that was the broader vision with which I started this institution a few years back.
So that is really
and since
inspiring.
Yeah.
Yes, sir.
So, I mean, I hope this broadly answers the question that you're trying to ask. And
Yes, so it did answer, and it was really like truly inspiring what you said, and it was really inspiring. So my second question to you would be, sir, you have invested significantly in your professional development, from APCAM certified training to attending the Indian Mediation Weekend, and you have been a speaker for All India Student Forum, guiding freshers on ADR competitions. For the thousands of law students listening to us right now, what credentials, trainings, or experiences actually make a difference in building a career in arbitration and mediation? How should a young professional or practitioner decide which path to pursue?
Of course. So trainings, I mean, so whenever I send my CV, or if you look at my LinkedIn profile, you'll find that I keep posting about some or other training every once in a while. And some people still ask me that, why do you need to do trainings now? I mean, you've already done a significant amount of trainings. But I feel that is one thing which we always need to do. I mean, irrespective of the fact that whether we have spent 4 years, 5 years, or 10 years in the industry, there's always something new which keeps happening. And to stay relevant, to stay up to date, and to get more work, of course, at the end of the day, you need to keep upskilling yourself. So I feel, I mean, when you get out of law school, I know that things are changing a lot now, but back when at least we used to be in law school, there was not a lot of focus on practical skills. I mean, we used to study a lot. So as I mentioned, in my undergrad, we had one subject which was ADR. So in one 3-credit subject, we were taught everything about arbitration and mediation, which is practically not possible because these are very broad domains in itself individually, you know. So when I got out of law school, I realized, getting into these trainings, that the processes were very different from what we were taught and we were studying, you know, because I did participate in 1 or 2 mediation competitions when I was in college. But again, the processes are still very different. A mediation competition or an arbitration competition is a mock version of the actual proceeding. So the trainings helped me there. Now, of course, things have changed a lot since then, because when I did my training first, there were a very handful number of training providers in India. And now today, if you look out, every other post on LinkedIn would be about some form of training, you know, because there are so many new players coming up, a lot of trainings on mediation, arbitration. So I guess while we decide to do training, it's very important to identify what kind of training are we actually signing up for. Is it just something that I want to do and add to my CV that I'm a certified mediator, or is it actually doing some form of value addition? What we often miss is while doing these trainings is that we don't ask or look for what content or curriculum are they going to cover. Most of these trainings will never tell you about that. There will be just a post which will tell you that these dates we are doing this program and that is the cost and these are the trainers. And we feel that these are enough pieces of information for us to be making that decision, which I feel ideally is not the case, or it should not be at least.
Yeah.
Because the purpose of going to the training is not just to listen to one individual there. The purpose is to get those practical insights, things which you cannot find in a textbook. If I just wanted to know about how a mediation happens, I can go and read a textbook. It will tell you that you start with your opening statements, then you invite the parties to make their opening statement, you do private caucuses, you do joint caucuses. But that's just a theoretical part of it. What is important is to gain those first-hand experience. So when I hear a practical or a practitioner coming in, someone who comes with a significant experience, that is where I get to learn. Though suppose some hostile situation occurs in a mediation, then how do I respond to that situation as a mediator? So I feel a few things that I feel today's generation should keep in mind while deciding which training programs they should offer. First is, of course, look at the curriculum. Look at what is the actual structure of these trainings, because a lot of these trainings, and I'm telling this from a personal experience because I've been associated with a global firm for the last 3-4 years who do conduct a lot of training programs across 45 countries, and in that process we do partner and talk with a lot of different other institutions as well. So I've seen how shady these training practices are getting day by day. So it's always good to have a clarity of what is being offered and delivered. It's always good to know who your trainer is, because the trainer, so a large part of Indian trainings that I see, you will just find lawyers training you, specifically in a process like mediation. However, I feel, I've interacted with a lot of exciting and good trainers who are working from places like UK, Dubai, even in some parts of Europe. So the trainer profile, the kind of experience that trainer brings in is also something which plays a very significant role. And the third and the most important thing, which I feel is important again, if you want to work not just in India, but globally, because a lot of cross-border arbitration and mediation are coming up, right? So if you want to work globally, so one of the most important factors is looking at the accreditations, because some of these training programs come with certain accreditations. Suppose like if you're reading out my intro, you mentioned about I being accredited by SIMI, which is the Singapore International Mediation Institute. Then we have the IMI, which is the International Mediation Institute based out of Netherlands. Similarly, there are different accrediting bodies. So it's very important to see if the training program or the course that you're signing up for, is it bringing some sort of accreditation or additional benefit for you? Because these programs are very highly priced. So it does not make sense, specifically from a law student's perspective. Once you're out of college, you're fresh, you're still looking to make money before you invest more, because you've already invested a significant amount in law schools today, right? So I feel these are the factors which we all should keep in mind. And of course, just because you have done one training, so this is general perception I've seen, especially in lawyers, because I interact with a lot of lawyers and I've been a part of trainings and I've conducted trainings with people who have had good 20, 25, 30 years of practice experience. There's a general perception that if I suppose I've done a 40-hour mediation training offered by one particular organization, I don't feel the need to do any other training, because I'm living in a world where I feel that I'm already competent enough to not maybe upskill myself. So that is one ideology I am not very comfortable with, and I feel as a professional, especially for young graduates, once you're starting your journey, you should keep on going, do a training today, then maybe in a couple of years, find what is happening and then upskill yourself again. So that should be a continuous process.
Yes, sir, that was really truly insightful for me as well, and it will also be really helpful for me. And I hope that will be the same case with our viewers, because people do get really confused that how to choose their credentials. And if, as you said, that people are that who have this perception key, if they do a mediation training certificate which is of 40 hours, and they will be a proper mediator. But as you said, that practical exposure or experience is something which is most important. And with your insights, I feel that they will be able to make now a proper decision with this. So So the third question to you would be, one thing that really stands out is the breadth of your practice, like air and space law, energy laws, environmental and climate change. These aren't typical areas we associate with arbitration. How did you develop expertise in these fields, and what role do you see ADR playing in resolving disputes in these emerging and highly specialized sectors, sir?
Sure. So I think there are a lot of underlying reasons for that, and this is not something recent. I feel this has started back when I was thinking to join a law school, because a lot of people still asked me why did I do my undergrad in energy laws, because that's a very niche area, and you won't find a lot of people who are actually that passionate and interested. So I think this is something I was very particular from the very beginning of my journey in the law school, that I did not want to pursue the old traditional paths of maybe just a criminal or a constitutional law. Of course, these are subjects we all study as a part of our curriculum. So we do have a good understanding and knowledge of it. But when it came to thinking about working professionally, I felt that identifying niche areas will open up more opportunities for me. Now, this is my personal opinion. Of course, this is subjective and it can differ from person to person. But my initial idea of opting for these specific and unconventional streams of law was because I realized that these are very fast growing. So if you look at air and space law, when I joined in my law school, it was growing rapidly. And I see now there are a lot of new courses and work opportunities coming up, not just in India, but globally. Because these kind of work will keep growing in these specific industries. Similarly, if you look at energy, environment, and climate change, in today's time, it has become all the more relevant. And energy and climate change are two domains which are going to stay relevant for us as humankind, even today and maybe 20 years later. So that these were my ideas when I was making those choices, because I wanted to opt for field which have a lot of work scope and growth opportunity for me personally in the coming 10-20 years. That's how I used to think about it. And when I identified these unconventional areas, it was not based on the fact that how much of work already exists, but I always thought of it more like how much more work and opportunity can exist for someone like me 10-20 years from now.
Yes, sir.
And specifically these areas, so you will see when it comes to the practice of air and space law, when it comes to practice specifically in energy law. So for environmental law, you will still find a lot of litigants who are already existing, specifically in higher courts and supreme courts. But for energy law, because energy law is slightly technical, and the similar kind of challenge comes when you deal with specifications of air and space law. So for these fields, there are very limited number of individuals who will have that kind of specialization and understanding, because these fields don't just require the legal understanding, but at times you also have to get the technical understanding of things that happen in these domains. So I felt, given the kind of opportunity that exists because of the limited number of lawyers specializing into these domains, that is how I initially identified. So my interest in energy was there. My interest in air and space law came when I was working on my dissertation for my undergrad. So I wrote my dissertation on IPR and outer space laws. So it was a mix of both. And that's how I've been exploring different such domains so far. Even today, if there is something like gaming law is one such growing field which has recently started kicking up a lot, So I don't practice in that domain, but I'm now starting to pick up that and understand. So I feel it's always good to pick those fields, because at least as long as these fields are in their initial areas, the kind of opportunities that you can create for yourself as fresh graduates is a lot more. Because for fields like constitutional law or the criminal law, you'll already find people who have had 50, 60, or even maybe 70, 80 years of experience already existing in those industry, So those were my ideas when specifically picking those areas. Now, talking about the role of ADR in this. So all of these fields, specifically, if you talk about air and space law, if we talk about energy or climate change, now these are domains or sectors of law wherein the issues are not generally domestic. So you'll find a lot of air and space law related issues or disputes concern multiple jurisdiction and countries. It's not usually just one specific country which will find. So for maybe suppose there is some air accident which happened or some outer space related dispute. So these kind of disputes generally involve countries across different jurisdictions and borders. In such cases, as we have time and again realized and discussed, that processes like arbitration and mediation become all the more relevant. Because for something like arbitration, we have a uniform convention, the New York Convention, which is something which major economies across the world abide by, so that creates a uniform mechanism for all of them to first, of course, address that dispute. And once that has been addressed, so once you have an outcome, that is an award in an arbitration, so the enforceability of it becomes a lot more easier compared to a foreign party coming to the Indian courts and enforcing the outcomes. So I feel in such cross-border disputes, in such kind of disputes specifically which concern more than one country involved, or parties from more than one countries which are involved, processes like arbitration and of course mediation is also now growing significantly after the Singapore Convention was introduced recently in 2019. These have become more relevant, and the relevancy is going to grow further. I feel very optimistic about it, something which not most of my lawyer friends would agree with me, but given that I have had my fair share of experience in ADR, so I feel really passionate and optimistic, and I feel within the next 5 to 10 years mediation is going to pick up even more than arbitration did over the last 2-3 decades. So yeah, that's how I feel about the role of ADR in these specific industries.
Yes, one should definitely like explore everything, because as you said, like when we talk about constitutional and criminal law, it's like very conventional, and people, most of the majority of the population go for that only. So it's like it was quite interesting to know this was how you planned for it, and it was actually truly motivating, and I hope it will be the same for others as well. So, sir, as the CEO and Executive Director of SACADR, you are not just a practitioner, you are building an institution. You were also present at the inauguration of the Arbitration Bar of India at Bharat Mandapam, and attended the IIAC conference with the Attorney General announced the All India Arbitration Bar. How do you see these institutional developments both at SACADR and nationally shaping the future arbitration of India?
So, Shreyansh, so this is one debate, which is something I have been personally participating in a lot, and I've heard a lot of seniors talk about. So, when you talk about arbitration, it has also now started to come up for mediation, but for arbitration particularly, this has been a long ongoing debate. Whether ad hoc arbitration is the future, or is it the institutional arbitration that is actually going to make India the desired hub for parties to come and resolve their disputes. So, I personally have been more favoring the institutional side of it, because for a country like India, and specifically, so when the arbitration bar was launched, a lot of dignitaries had this similar opinion, and that is something we keep discussing in a lot of these events and gatherings that we meet in, is that we need to have a centralized system for a process this complex or as easy at the same time, I feel. Because when you look at ad hoc arbitration and mediation compared to institutional arbitration and mediation, the process and the entire experience of the parties changes a lot. Having more dedicated institutions is something which I feel very important for a country like India. A very good example is something we take is the Singapore International Arbitration Center. The SEAC has been one of the leading examples we should always, I think, keep learning from. And on the similar lines, they also have the SIMC, which is the Singapore International Mediation Centers. And I feel these two institutions have played a very significant role when it came to shaping Singapore as the preferred destination for resolving disputes, because before that, London Court of International Arbitration was something, LCIA was something which was ideally preferred by the parties, and the parties then shifted to something more new comparatively, which was SEAC. And SEAC has grown exponentially over the past 1 or 2 decades. If you look at the growth story, if you look at the kind of and the number of cases they have been dealing, it has grown tremendously. So I feel what we need to realize today is that having proper dedicated institutions have become all the more necessary. It's not just important, it has become a kind of a necessity because we need to regulate these processes well. Now, why I also say that is because these processes are fairly new for the parties who are the end users of these processes, right? And in such a case, when you don't have a good experience with the process, which is highly possible if it is an ad hoc arbitration or mediation, then the likeliness of you engaging and opting for that process going ahead reduces. On the other hand, when we have a dedicated institution, you have a dedicated and set rules and regulations already in place. You will already find that a lot of these institutions have a set panel of arbitrators and mediators. So that makes the process more efficient because you have a large pool of experts to choose from. And specifically when you opt for arbitration, so arbitration are obviously one of the most important positives about arbitration is that you get to have specialized individuals to deal with the dispute. So if I'm dealing with a construction dispute, I can have an option to choose an arbitrator who specializes in construction disputes, so I think all of these positives come more efficiently when you are having an institution. Now, in India particularly, I mean, there have been a growing trend of having some institutions. So, I mean, MCIA has been a really good example, Mumbai Center for International Arbitration. They started somewhere around 2015, 2016, and they've been doing some good work. In Delhi, we have the DIAC, which is the Delhi International Arbitration Center. Then we have the IAMC, which is International Arbitration Mediation Center in Hyderabad. So some initiatives are coming up. But again, the problem that I personally feel and realize is, as I mentioned, that these initiatives are restricted to the metros, which is of course because of some logistical and operational reasons and challenges, but that defeats the actual purpose of having these institutions. Because if you look at the national judicial data grid, you will see from the approximate over 50 million cases that are pending in the Indian courts, a major chunk of it, over 80 to 85%, comes from the lower courts.
Yes.
So since the major chunk comes from the lower court, the actual need of adopting these processes is in the lower courts. So we cannot have a fruitful outcome until and unless these institutions are restricted to places like Delhi or a Bombay or a Bangalore. We need to have more of these institutions. Of course, the Arbitration Bar of India was a good initiative and a launch in the right direction, but the process to translate this into an outcome has been very slow. It's been a couple of years since that happened, and we've not seen something significant happening out of it. So I feel like, for the example, I started SACADR with the vision to have something in a tier 2 town. So such initiatives should come up. And once we have such more institutions, because 2-3 institutions for a country like India are not a viable alternative, because we have very limited options. And since I personally interacted and worked with a few of these institutions, so I'll tell you, the cost of these institutions are very high. So the chances of individual parties to go and use these institutions is again very limited. So it is restricted in a way to those who come with a higher paying capacity. So I think a lot of these institutional challenges are there, but even so, having a proper dedicated institution is going to help us move forward in the direction of making India the hub of dispute resolution. So of course, we should have more and more of such institutions. Maybe such institutions will come in states like Uttar Pradesh and Uttarakhand and Madhya Pradesh. A lot of these states need that. And I think that's where the actual need for awareness and adoption is. So yeah, that's what I feel about it.
Yes, like I got a lot of clarity as to it, and the initiative which you have taken is also really nice because it will help people at the rural communities. They will be able to approach people and they will resolve their disputes with the help of mediation. So, sir, the last question of today would be, sir, you have served as a global operation director at the ADR ODR International, and you have spoken about how collaborations bridge the gap between the academia and industry practice. From your perspective, what is missing in the legal education today when it comes to preparing students for ADR practice, and what should law students be doing differently to produce practitioners who are truly ready for the field?
Sure. So, I mean, things are changing, as I said. So, because back when I was in law school, I had one subject. For me to maybe even get interested in ADR was not possible because, in one semester, we used to have good 8-9 subjects back then. And in such a case, just one subject, you briefly read through it, and the possibility of you knowing more about it was very limited back then. Now, because I do interact and participate in a lot of these competitions that keep happening across India and outside India as well. So I've seen a lot of colleges are now at least taking initiative. Now, these initiatives sometimes are in form of different competitions. So a lot of new competitions in mediation, arbitration, negotiation have started shaping up. So I feel this is one good starting point. However, this still needs a lot of refinement because in the competition, the process and structure is still very different from what actually happens in mediation or in arbitration. So I think law schools, since they are taking this initiative, they should, of course, keep promoting it more. I think this usually helps students a lot, and the kind of participation that I see now, because when I was in law school, so that was the year my law school first started the intra mediation competition, which was an internal competition for the students of that law school. And the kind of participation and interest was very limited. So people were more fascinated about doing moots. There were so many national and international moots happening. So the kind of passion you would see in the eyes of people when they were actually going for a moot was very different compared to what kind of passion you would see when they came for a mediation competition. So I think that has increased a lot. I personally, attend a lot of such competitions across India. I was recently at NUJS. NUJS organizes one of the biggest international mediation competitions in India. It's really good. It was a good experience. I saw a lot of participants coming in from different parts of the country and from some other parts as well. MNLU, Mediation Championship, Bombay, the arbitration competition. So a lot of these activities I feel are a good starting point, but you should never keep yourself restricted to that. As a law student, if you want to engage, there are multiple avenues to start your journey. Of course, competitions could be one. Research, I feel, is a very important thing that you as a law student should definitely work on, because research does two things for you. First is, of course, it exposes you to the knowledge that you are not generally shared with as a part of your curriculum. Maybe as a part of your curriculum, you just taught about arbitration broadly, and you picked up one specific part of arbitration, maybe something about investment arbitration to begin with. Now, if you want to write a research paper or something, you'll go on and read more. So I think research and writing is one very important thing which will give you a very good overview and understanding before you step into the actual practice. And for processes like arbitration, you need to read a lot as well, because there have been so many judgments within India and in international arbitration that you need to have a good understanding of. So I feel research and writing again can open up really good opportunities for you. And when I say research and writing, so that is not something which is just limited to yourself. I personally have seen a lot of law students working with senior professionals and senior professors and co-authoring papers with them, So these kind of experiences, I think, can be a good starting point as law students. Of course, you do internships, but what are you actually doing and learning in that internship makes a lot of difference. Because for arbitration and mediation, so what happens usually is, at least something I hear from a lot of young professionals, is when you go to ADR institutions, you expect that you'll get all kind of legal work, which is not quite the case. Because arbitration and mediation institutions do a lot of legal work, but at the same time, they also do a lot of operational and managerial work as well. So I see a lot of young professionals not taking up those opportunities because they feel, no, we studied law, so we wanted to do something purely legal. So I get that idea, but at times when you're starting your journey with ADR institutions specifically, you will be required to do a lot of managerial work, a lot of administrative work as well. You won't directly get, you should never expect directly to get an arbitration or mediation appointment, because that is not practically happening right now in the country. So I think the mindset, we should not keep it restricted. Of course, we want to do legal work. There's always more and more scope to do that. But at the same time, things might take a little time. So we have to be patient and be a part of the process. And that's how I think we can pick and learn. That's one thing about purely working as an arbitrator or mediator. Now, there are people in my contact and my friends as well who have been working with retired judges and senior advocates who just do arbitrations. They don't do litigation, but they're now purely into arbitration. So working with such individuals can be a good starting point. Of course, you don't get to again be directly an arbitrator, but you can assist them. So there are posts called tribunal secretaries. So ideally, this is an individual who manages and coordinates the entire logistics of the arbitration process, and he is the central point of contact between the arbitrator and the parties and lawyers of both the sides. So such experiences will first get you inside the room. And I think that's one very important step that we miss. We need to first get in the room to actually be able to learn and pick something from there. And once we have had those experiences, then over the next couple of years, you can keep translating it into something more meaningful. Other than that, one additional thing that is really good and happening, at least at this time, is the ODR platforms. There are so many online dispute resolution companies which can give you opportunity to start your journeys as case managers. And then, of course, after you gain 3-4 years of work experience or 3-4 years of experience at the bar, you have the option to also act as a neutral, which is as a conciliator or an arbitrator. So I think these kind of opportunities are opening up more, specifically with the tech coming in. So a lot of online work is happening, and so many changes have been happening in tech, AI, and a lot around legal tech specifically. So I think these opportunities will keep coming up. And when it comes to specifically bridging the gap between academic and practical understanding of things, all you can learn is by observing, by participating, and by practicing yourself. So even if you're not able to practice, do not get disheartened. You still can learn a lot by observing. But in order to observe, you have to get into certain places, which I think can happen only once you start your journey. So yeah, I mean, that's what I feel about that. Other than that, I mean, I personally try to attend some lectures. I do take some lectures occasionally across different universities whenever possible. But of course, given the time limitations, it's not possible to do a lot of those things. So I feel what's also important is, as a student, you have so many platforms to connect with professionals directly. So use those opportunities. There are so many conferences, events, and such similar gatherings which keep happening, and these gatherings are open to both students and professionals. So as students, we should use these opportunities to go out, to make that connection, which can maybe open some exciting door of opportunity for you. If not that, at least there will always be something for you to learn. So keep that in mind, but at the same time, also keep your focus equally on reading and researching, because I think that's one thing that the current student generation is losing touch of, because we are too much into screens. 95% of our day goes into screens. So we are losing a touch of reading and understanding things. So we should always at the same time keep doing that, I feel. Yeah.
So that was truly insightful, because I am also in my first year and I have taken my notes, and I feel this was genuinely really insightful. And so this has been an absolute incredible conversation. I think what stand out most is that you have shown us that building a career in ADR isn't just about knowing the law. It's about being curious, being willing to learn across sectors, investing in your training, and ultimately having the courage to lead. From air and space law to the arbitration bar of India, from the classroom to the CU's chair, you have demonstrated that field of dispute resolution is vast as our imagination shows it to be. Thank you so much for taking out your time and being us today with us and sharing your wisdom so generously. To our listeners, if this episode made you think differently about what possible a career in ADR, do drop a comment, hit a like, and share it with someone who needs to hear this. Let's keep building a culture where dialogue is preferred over conflict. Until next time, this is Shreyansh Srivastava signing off. Keep choosing resolution.
वीडियोस बनाने हैं, फिल्मोरा है ना।